Hi guys, we're going to talk about Chapter 5, and this is going to look at legal and legislative issues. The primary purpose of law and legislation is to protect the patient and the nurse. Laws and legislation define the scope of acceptable practice and protect individual rights. Nurses who are aware of their rights and duties in legal matters are better able to protect themselves against liability or loss of professional licensure. So let's dive into legal and legislative issues. Types of law in courts include criminal, civil, and administrative. Charges are filed in criminal cases with the individual presumed innocent unless proven guilty beyond a reasonable doubt. So practicing without a license, misuse of narcotics, theft, murder, those would all be our criminal law cases. Nurses found guilty of intentional administering fatal doses of drugs to patients would be charged as well in criminal court. When we look at civil cases, these are when one individual sues another monetarily to compensate for a perceived loss. Burden of proof is required to be found guilty in a civil case. It's described as preponderance of the evidence. The judge or jury must believe that it was more likely than not that the accused individual was responsible for the injuries of the complainant. Most malpractice cases are tried in civil court. And then administrative cases are when an individual is sued by a state or federal government agency. So an example of governmental agency is the State Board of Nursing. If an individual violates the State Nurse Practice Act, the Board of Nursing may seek to revoke licensure or institute some type of discipline. Healthcare professionals are required to know and follow state laws regulating their license or registration. When we talk about the types of negligence, the one we are most in tune with is ordinary negligence. We can define ordinary negligence as the failure to act as a reasonable, prudent person, guided by the considerations that ordinarily regulate human affairs would do, or doing something that a reasonable and prudent person would not do. Professional negligence or malpractice is a failure of a person with professional training to act in a reasonable and prudent manner. We will get more into malpractice here in just a second. So we've already kind of defined malpractice here, but here it is on a slide. So the failure of a person with professional training to act as a reasonable and prudent manner is called professional malpractice or negligence. All liability suits involve a plaintiff, the injured party, and a defendant, who is the professional alleged to have caused the injury. When we think about defining negligence, it's the omission to do something that a reasonable person, guided by considerations that ordinarily regulate human affairs. Remember, ordinary negligence. Or doing something that a reasonable and prudent person would not do. So examples of negligence might include side rails left down, patient falls from bed, using or not reporting defective equipment that injures a patient, maybe patient develops an infection from poor sterile technique by the nurse, or maybe the patient was burned from bath water that was too hot. 5 components that are necessary for professional negligence. First, a standard of care is in place, meaning a minimal level of expertise is delivered to the patient. The standards of care outline the duties a defendant has to a plaintiff or a nurse to a patient. That care should be given under circumstances, so what the reasonable, prudent nurse would have done. The question of whether a nurse acted with reasonable and prudent care is determined by the testimony of expert nursing witnesses. After the standard of care has been established, it must show that there is a failure to meet that standard of care or some type of breach of duty. so not giving the care that should be given under the circumstances. The nurse must have had the knowledge or availability of information that not meeting the standard of care would result in harm, and that is the third component. This is called foreseeability of harm. Ignorance is not an excuse. Being ignorant is not a justifiable excuse, but not having all the information in a situation may impede one's ability to foresee that harm. The fourth element is that failure to meet the standard of care must have the potential to injure the patient. So there must be some type of provable correlation between care and harm. And then the final element is that actual patient injury must occur. So why do nurses have increased legal liability? Nurses have gained a significant more authority, autonomy, and accountability for their own practice and decision making. As the nurse role expands, they are beginning to perform duties traditionally reserved for medical practice. As the nurse's scope of practice is increasing, many nurses now carry their own malpractice insurance, and often those who are suing look to sue those who have the most financial resources. So again, many nurses do carry individual malpractice insurance. This is sort of a double-edged sword, and basically because if patients know you have a malpractice insurance, they're going to be a little bit more sue happy because they know you have the financial resources to back it. So as a reminder, being ignorant is not a justifiable excuse, but not having all of the information in a situation could impede one's ability to foresee harm. So under ordinary circumstances, this is just kind of a recap here, right? The question of whether a nurse acted with reasonable and prudent care is determined by expert nursing witnesses. Just following physician orders is not a defense for malpractice. Nurses have an independent responsibility to take appropriate steps to safeguard their patients. We need to practice within the scope of the Nurse Practice Act. Observe agency policies and procedures. Model practice after established standards by using evidence-based practice. Always put patients' rights and welfare first. Be aware of relevant law and legal doctrines and combine such with biological, psychological, and social sciences that form the basis of all rational nursing decisions. Practice within the area of individual competence. Upgrade your technical skills consistently by attending continuing education programs and seeking those specialty certificates. So frequent causes of claims against nurses, you can see them written here. They can include inadequate charting, right? If it's not charted, it's not documented, it's not done. So make sure your charting is adequate. Inadequate communications with physicians or supervisors about any patient condition changes. So if your patient is crumping, deteriorating, make sure you have really good communication with your physician, your charge nurse, your manager, whoever you need to be communicating with. Leaving potential harmful items within patient reach. I think the biggest thing would be like a needle stick, right? You give an injection, you put the needle next to the bedside, right? Somebody picks it up, family member, patient, and it becomes a potential harmful item. Unattended patient falls, inaccurate counting of operative instruments and sponges, right? The last thing you want to do is be in the OR and have a missing sponge that now your patient is sewn up and there it is inside of them. And then misidentifying patients for medication, surgeries, and tests. Don't take the wrong patient to the surgery. Don't give the wrong medication to the wrong patient, right? These are frequent causes of claims against nursing staff. Incident reports and adverse events forms. These are records of unusual or unexpected incidences that can occur during a client's treatment. Attorneys typically use incident reports to defend the health agency against lawsuits brought by clients. So generally, these are considered confidential communications and cannot be subpoenaed by clients or used as evidence in lawsuits in most states. Incident reports should never be documented in the patient's chart, and no record should be indicated in the chart that an incident report was documented. So when we think about torts and legal wrongs committed against a person or property that renders the person who commits them liable for damages in a civil action. Intentional torts include assault and battery, false imprisonment, invasion of privacy, and then defamation of character. Nurses can be sued for assault and battery, assault being the conduct that makes a person fearful, and then battery being the intentional physical contact that gives injury or maybe offensive touching. So some examples of assault and battery could include patients being handled roughly or with excessive force, maybe performing treatments without the patient's permission or without receiving informed consent, or even restraining our patients that may be confused. Excuse me. False imprisonment is the unlawful confinement within fixed boundaries. Invasion of privacy is the unjustifiable intruding of another's right to privacy. This could be searching through patients' belongings without their permission, reviewing or releasing patient information to colleagues, other patients, or even media. Defamation of character is defined as communication to a third party. False information that injures a person's reputation. It could cause economic damage, it could diminish self-esteem, it could diminish respect, goodwill, or confidence. Slander is the spoken information, so stating a person has a drug problem, where libel is the written, so printed or broadcasted information. Sending inaccurate lab results to government agencies would be that written. We have discussed restraints with your previous modules, knowing that restraints of movement has led to claims of false imprisonment. This can be produced by physical, emotional, or chemical means. An example is having the side rails up without a doctor's order and patient's permission. All 4 side rails up. Placing patients in restraints without order or permission, keeping patients hospitalized against their will. So there are 3 types of consent: informed consent, implied consent, and express consent. The one we're most familiar with is informed consent, and that's the one we're really going to focus on in this chapter. Informed consent is obtained only after the patient receives full disclosure of all pertinent information regarding the surgery or procedure, and only if the patient understands the benefits and risks associated with doing so. Informed consent can be given by a competent adult, a legal guardian or individual holding durable power of attorney, an emancipated or married minor, a parent of a minor child, mature minor, could vary by state, and if it's court ordered. Patients also must have reasonable access to their records. Collaboration between healthcare providers and patients, documentation thereof is a good indication of well-provided clinical care. If you have to correct a mistake on any documentation, do not erase or mark out mistakes made on patient records. Cross out errors, one single line, through the information in handwritten records, or have a computerized system that tracks those changes. Insert the correct information, initial, and date it. The Patient Self-Determination Act, or PSDA, was enacted in 1991, and this act required healthcare organizations that received Medicare or Medicaid, that federal funding, to provide education for staff and patients on issues concerning treatment and end-of-life issues. This education included advanced directives, written instructions regarding desire for end-of-life. The act also likely included durable power of attorney for health care, so healthcare proxy. A durable power of attorney identifies an agent or a person to make decisions or perform other acts on a person's behalf if they become unable to do so themselves. This really encourages all people to make choices and decisions about how the types and extent of medical care they want to accept or refuse should they become unable to make those decisions due to illness. Nurses are not required to stop and provide emergency services, even though healthcare workers feel ethically compelled to do so. The Good Samaritan law is put in place to protect nurses that do stop and help for an emergency situation. We are all familiar with HIPAA, so the Health Insurance Portability and Accountability of Act of 1996 protects our patients' privacy and health information and improves portability and continuity of health insurance coverage. License is a legal document that permits a person to offer special skills and knowledge to the public. Licensure establishes standards for entry into practice, defines a scope of practice, and allows for disciplinary action. Licensing for nurses is a responsibility of the State Board of Nursing or State Board of Nurse Examiners. So the Board of Registered Nursing protects citizens by licensing our RN, right? We have to go to school, we have to get an education in order to get that license. They're going to monitor educational standards of the RN. They're going to require continuing education to keep the license current. And then if there's any concerns, they will discipline the RN. Boundaries for practice are defined in the Nurse Practice Act for each state. So just make sure you're familiar based on what state you are practicing in. What are those boundaries? Remember, RN licensure is a privilege. It is not a right. Boundaries for practice are defined by the Nurse Practice Act for each state. These acts are flexible because this allows for some misinterpretation. Many employers have specific guidelines for practice at their institution. And although these guidelines are established by organizations, these guidelines cannot supersede the Nurse Practice Act. We have to be aware of and follow the Nurse Practice Act within our own state. So what are some of the legal responsibilities of the nurse manager? It can include reporting dangerous understaffing, right? That puts patients at risk, checking staff credentials and qualifications, and then carrying out appropriate discipline. Standards of care and policies and procedures can vary from facility to facility, so nurse managers should be aware of their facility standards so that liability posed on the nurses for not following policies and procedures can be corrected and eliminated. So when we talk about a license, we're talking about a legal document that's really permitting that nurse to offer special skills and knowledge to the public when such practice would otherwise be unlawful. Licensure establishes standards for entry into practice. Again, it defines the scope of practice and it allows for that disciplinary action. Remember, professional licensure is a privilege. Nurses that violate norms of conduct may have their license suspended or revoked by the licensing board. Some frequent causes of license suspension or revocation can include professional negligence, obtaining a nursing license by fraud, maybe a felony conviction, criminal abortions, not reporting substandard medical care, giving narcotic drugs without an order, or maybe even falsely holding oneself out to the public as a nurse practitioner when you actually don't hold that license. And that concludes Chapter 5. If you have any questions, you can shoot me an email or we can chat about it in class. Thanks, guys.